President Trump refuses to turn planes around carrying enemy aliens, defies Imperial Judiciary. Hello, this is Robert Romano, Executive Director of Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button. Today, we're going to be talking about President Trump's removal of about 250 enemy aliens, as they are called, under the 1798 Alien Enemy Act. That have been removed to El Salvador. They're at San Salvador, and then that was on Saturday, on March 15th. The president issued a proclamation, and he must have had these enemy aliens waiting on the tarmac, and the plane was taking off because they were already on their way to El Salvador when the ACLU attempted to have a U.S. District Court Judge James Boasberg issue a restraining order, an injunction, and ordering the planes to turn around. Which probably doesn't sound too safe. It's like they're halfway to El Salvador, and it's like, no, turn back around. You have to come back. Instead, the planes proceeded to El Salvador, and now the 250 Trenderagua and other criminal drug cartel gang members are in prison, and they're gone. They're history. So President Trump was defying what I'm calling the Imperial Judiciary. Well, some people are saying, oh, this is an Imperial presidency. Well, I'm saying, no. What you have here is an Imperial Judiciary. And so we're going to be talking about my piece today, which I think is, we want to go here. And then we want to go, let's see here, go over here. And you should be able to see my piece right now. Hopefully that's working as it should. And we're just I'm going to read from it, but I'm also going to show you things like the court order. We're going to go over some documentation. We're going to talk about the 1798 Alien Enemy Act that was under the John Adams administration. We're also going to talk about the 1952 and 1965 Immigration and Nationality Acts. That's what the ACLU and the judge are arguing Trump is somehow violating by invoking the Alien Enemy Act, even though the Alien Enemy Act was never repealed. President can do so via proclamation. We're going to be talking about his proclamation. We're also going to be discussing him designating these groups as terrorist organizations, all things that Congress has authorized. Congress has authorized the Alien Enemy Act. It's authorized the ability of a president to therefore remove enemy aliens under that act, and also the ability to designate terrorist organizations, which president has done here, and then to proceed to the removals. Again, I think that this is actually a pretty easy case when you consider just the letter of the law, and we're going to look at the laws as well, because I think that they are relevant. But here we go. President Trump refuses to turn the planes around. President Donald Trump on March 15th issued a proclamation declaring that Venezuelan-sponsored terrorist drug cartel gangs, including Trenderagua, so declared as terrorist organizations on January 20th by executive order in accordance with 8 U.S. Code Section 1189, designation of foreign terrorist organizations, were engaged in an illegal invasion and thereby subjected to the 1798 Alien Enemy Act. Now, here is the designation of the cartels and other organizations from whitehouse.gov. If you want to get information about what President Trump is up to, just go to whitehouse.gov, and you can click on the newsroom and see what presidential actions have been occurring. Designating cartels and other organizations as foreign terrorist organizations, and specifically especially designated global terrorists. And so here we go. Designating cartels and other organizations as foreign terrorist organizations and especially designated global terrorists by the authority vested in me as president by the Constitution and laws of the United States, including the Immigration and Nationality Act, the International Emergency Economic Powers Act. It is hereby ordered. Is to create a process by which certain international cartels will be designated as foreign terrorist organizations. They constitute a national security threat beyond that posed by traditional organized crime, with activities encompassing converging convergence between themselves and a range of extra-hemispheric actors, from designated foreign terror organizations to antagonistic foreign governments, complex adaptive systems characteristic of entities engaged in insurgency and asymmetric warfare, and infiltration into foreign governments across the Western Hemisphere. And then it goes on to name a number of these organizations, including MS-13 and Trenderagua. Their campaigns of violence and terror in the United States and internationally are extraordinarily violent, vicious, and similarly threaten the stability of the international order in the Western Hemisphere. So therefore, they are now terrorist organizations, and the president absolutely has the power to so declare them to be terrorist organizations under 8 USC section 1189. Here it is. There we go. I'm going to zoom in a little bit here. The secretary can, under the president's direction, essentially declare organizations to be terrorists. It's right there in the subtitle here. And so, it's a pretty basic case there. And so the president declared them to be terrorist organizations. And then he issued a proclamation on March 15, invocation of the Alien Enemy Act regarding the invasion of the United States by Trenderagua. Trenderagua is a designated foreign terrorist organization with thousands of members, many of whom have unlawfully infiltrated the United States and are conducting irregular warfare and undertaking hostile actions against the United States. Trenderagua operates in conjunction with Cartel de los Soles, the Nicolas Maduro regime-sponsored narco-terrorism enterprise based in Venezuela, and commits brutal crimes, including kidnappings, murders, extortions, human, drug, and weapons trafficking, and has been engaged in mass illegal migration to the United States to further its objectives of harming United States citizens, undermining public safety, and supporting the Maduro regime's goal of destabilizing democratic nations in the Americas, including the United States. They're closely aligned and has infiltrated the Maduro regime, including its military and law enforcement apparatus. And so it goes on to give you more background about the organization. And then it says, I find and declare that Trenderagua is perpetrating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. Trenderagua is undertaking hostile actions and conducting irregular warfare against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. I make these findings using the full extent of my authority to conduct the nation's foreign affairs under the Constitution. Based on these findings and by the authority vested in me in the by the Constitution and the laws of the United States of America, including 50 USC Section 21, proclaim that all Venezuelan citizens 14 years of age or older who are members of Trenderagua are within the United States and are not actually naturalized or lawful permanent residents of the United States are liable to be apprehended, restrained, secured, and removed as alien enemies. I further find and declare that all such members of Trenderagua, by virtue of their membership in that organization, chargeable with actual hostility against the United States, and are therefore ineligible for the benefits of 50 USC Section 22. I further find and declare that all such members of Trenderagua are a danger to the public peace or safety, and he directs the Attorney General within 60 days to prepare and publish a letter under her signature declaring the policy described in Section 1 of this proclamation as the policy of the United States, and attaching this proclamation to transmit the letter to the Chief Justice of the United States Supreme Court, the Chief Judge of every Circuit Court of Appeals, and the Chief Judge of every District and Territorial Court of the United States, each governor of a state and territory, and the highest ranking judicial officer. I direct that all alien enemies described in Section 1 are subject to immediate apprehension, detention, and removal, and further that they shall not be permitted residence in the United States. So this is where we're going to go and look at the Alien Enemy Act at 50 U.S. Code Section 21, restraint, regulation, and removal. Whenever There is a declared war between the United States and any foreign nation or government, and any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the president makes public proclamation of the event, all native citizens, denizens, and subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. It further provides that the president is authorized in such an event by his proclamation thereof to direct the conduct to be observed on the part of the United States toward the aliens who become so liable, the manner and degree of the restraint to which they shall be subject, and in what cases, and upon what security their residence shall be permitted, and to provide and to provide for the removal of those who, not being permitted to reside within the United States, refuse or neglect to depart therefrom, and to establish other regulations which are found necessary in the premises and for the public safety. So as you can see, Congress has authorized exactly what the president has done in invoking the Alien Enemy Act. This is still the law of the land. He's allowed to issue this proclamation, and he's allowed to see to the removal of the enemy aliens, and also with the designation of foreign terrorist organizations. He did that on January 20th. It's one of the very first things Trump did when he was in office. And so it seems like the law is on the president's side here, that he has the power to remove alien enemies when he issues a proclamation. Again, he did that. He says that Venezuela is a state sponsor of terrorism, Nicaragua is a terrorist organization, and they are invading the United States. And when he says if there's an invasion or predatory incursion perpetrated by any foreign nation or government, the president makes a public proclamation of the event. Well, here's the proclamation. That's kind of it. That's what you would call a non-justiciable question, a political question by which the president has discretion. If you go back to Marbury v. Madison, it talks about what is a justiciable question, what is a political question. And this is a political question. The president has discretion to use war powers and to declare that there's an invasion when he believes there is an invasion. Now, you could disagree with the president. You can say, I don't think Nicaragua should be labeled as a terrorist organization, but it wouldn't remove the power of the president to declare them as such, as a terrorist organization. Or you could say, I don't think that the president should be invoking the Alien Enemy Act and removing members of Nicaragua, but it would not change the fact that the law of the land allows the president to do such a proclamation, to say that there's an invasion and to see to their removal. So I believe we've covered the bases on the proclamations and the law of the land and the Alien Enemy Act. And so we've covered this, provides that upon presidential proclamation, the president can remove them. It declared them to be a foreign terrorist organization, these proclamations, that they were invading the United States and that they're going to be removed. As a result of the proclamation, some 250 such enemy aliens were put on planes and promptly removed to El Salvador as the ink was drying from Trump's proclamation. Now, the planes took off at 5:45 p.m. Eastern Time on March 15th, according to justsecurity.org's Ryan Goodman. Now, this is an interesting blog that covers the events of the timeline of the U.S. flight to El Salvador and judge's order to turn around planes. We have this by Ryan Goodman of justsecurity.org. So it's referred to, if you click the link in the description, my piece actually links to this article. And so you can check it out yourself. And I'll go over some of the times here. So at 5:45 Eastern, the planes take off. Then around 6:53 p.m., U.S. District Judge James Boasberg ordered that the planes, by then already in international airspace, to turn around and bring the enemy aliens back home. And so here's the judge's ruling in the district court for the District of Columbia. This is the proposed temporary restraining order. You can find this on courtlistener.com. But I believe this is the one that went into effect. Having determined the plaintiffs are likely to succeed on the merits of their claims that the Alien Enemies Act 50 USC 21 does not authorize the president to summarily remove them. Well, that's not what we just read from the United States, that they have suffered violations of their rights under due process, the Immigration and Nationality Act. Therefore, they're likely to succeed. Therefore, we order this to stop. We're going to say, here it is, ordering pending further order of this court that insofar as any plaintiffs or members of the putative class are in the process of being removed or have already been removed from the United States pursuant to the Alien Enemies Act, but remain within the custody, control, and jurisdiction of the United States, such individuals shall be returned to the United States. Well, it's too late. Not only were they already on their way there, upon arrival, they are now under the jurisdiction of El Salvador, and El Salvador just locked them up. They're in prison already. So I don't think they're under the jurisdiction or control of the United States anymore. So I get, and by the way, Trump can just say they're inadmissible now. So even if someone tried to get them back, he could just say, well, no, they're inadmissible now. In fact, that's what the law provides for. And we'll get back to the law. But there's the judge's injunction that's been entered into effect. And so I'm calling this the Imperial Judiciary. The judge has no power to issue this order, as we shall see. The injunction said that the plaintiff's arguments that the deportations were a violation of the 1952 and 1965 Immigration and Nationality Acts were likely to succeed. So the argument the ACLU is making is that the modern immigration laws of 1952 and 1965 somehow trump or override the contents of the 1798 clearly worded Alien Enemy Act. There's just one problem, as I note in my piece. Neither the 1952 nor 1965 acts ever repealed the Alien Enemy Act, which is only invoked by a president upon a declaration of war or upon a presidential proclamation that there is an invasion. Presidents issued proclamation. And so I wanted to pull up also the 1952 Immigration and Nationality Act, that the court is citing. They're citing the 52 and 65 acts. So why don't we look at those acts and see if they actually, how do they treat alien enemies? This is, I think, actually very important. Let me zoom in here a little. All right, that should make it a little easier. One section of the 1952 Act, which the 1965 Act amends, but let's look at the original 1952 Act because it tells us whether Congress thought it was repealing the Alien Enemy Act. Section 212A, except as otherwise provided in this act, the following classes of aliens shall be ineligible to receive visas and shall be excluded from admissions into the United States. There's a lot of categories here, but one of them under subsection 17 here is aliens who have been arrested and deported or who have been removed at, or who have been removed as alien enemies. Let's read that again. So you're not allowed to be admitted into the United States if you're an alien who has been arrested and deported or has been removed as an alien enemy. What does this establish? That they are acknowledging there are still alien enemies, that the Alien Enemy Act is still in effect. That if somebody invades the United States, the president proclaims it so, he can start removing members of the invading army or militia or gang or whatever terrorist organization under the Alien Enemy Act, because the law, 1952 Immigration and Nationality Act, says that alien enemies are inadmissible under the 1952 Act. So they were invoking the 1798 law and they were incorporating it into the 1952 law. They were not repealing the 1798 law, which only gets invoked upon declaration of war or upon presidential proclamation, which happened on March 15th. But the last time it happened before that was in World War II. So then we go to the 1965 Act, which similarly it changes a lot of the provisions of the 1952 Act, and it also replaces Section 212A of the Immigration and Nationality Act in 8 U.S. Code Section 1182. So then it removes the mention of alien enemies or enemy aliens, and then it creates a bunch of other classes. So it's like, oh, they removed the alien enemy. So are enemy aliens now, are they allowed to be in the United States? Well, you'll remember 8 U.S. Code Section 1182, inadmissible aliens. It was the same law under subsection F that President Trump in his first administration issued the travel ban from several Middle Eastern countries that were known to harbor terrorists. He said people from those countries, they can't come here. And so Trump, he invokes 8 U.S. Code 1182. He wins the case, and then the travel bans were allowed to take effect. And so that this is a law that we've encountered before, and it's been upheld. And as we shall see here, it actually provides that alien, even though it doesn't mention enemy aliens, it still covers the enemy aliens. And so let's cover that. Instead, far from repealing the 1798 Alien Enemy Act, the 1952 Act explicitly invoked it and accepted enemy aliens from being permitted. We just covered that. And while the 1965 Act did amend this provision of 8 U.S. Code 1182, it no longer mentions alien enemies, as I just stated. The law still contains very similar provisions, specifically for aliens designated as terrorists, in subsection A3B, as also being inadmissible. So you have terrorists are in the subsequent amendments to this code. Terrorists are not admissible under the law, just like the 1952 law. Any alien who is engaged in terrorist activity is inadmissible. So president says they're a terrorist organization, they've engaged in terrorist activities, they're not admissible. Again, Judge Boasberg might have noticed that the president had also declared Tren de Aragua as a terrorist organization. So if you're a terrorist, you're not admissible into this country. So that's another aspect of, I think, the law that's coming into play here, is that Trump didn't merely invoke the Alien Enemies Act. He said that they are terrorist organization, and now we can say that they're inadmissible in the very least under, so none of them can come here for sure. So can we remove them? That's what we're going to get to. In any event, the 1965 law never repealed the Alien Enemy Act. In fact, prior to the March 15 proclamation, the Alien Enemy Act had not yet been invoked by President Trump and has not been invoked since World War II, meaning the Alien Enemy Act must be read consistently with both the 1952 and 1965 Immigration and Nationality Acts. In the normal course of events, that is, without a declaration of war or a presidential proclamation, the 1952 provisions still in effect and the 1965 provisions are the law of the land. But if there is a declaration of war, or if the president proclaims there is an invasion by the foreign country, in this case, Venezuela's narco-terrorist syndicate that includes Tren de Aragua, then the provisions of the Alien Enemy Act to, quote, provide for the removal of those who are not permitted to reside within the U.S., refuse or neglect to depart therefrom, absolutely come into play and appear to supersede, in my opinion, the 1952 and 1965 statutes. And we know that specifically because the 1952 statute put those arrested and deported as a separate class from those who are removed as alien enemies. Again, in the 1952 Act, aliens who have been, it says that aliens who have been arrested and deported, or those who have been removed as alien enemies, are not admissible into the United States. And those are separate categories. You are arrested and deported under regular immigration law, or you were removed as an alien enemy under the Alien Enemy Act. Those are not the same thing. Trump is invoking the Alien Enemy Act. He is not going through the traditional course of deportation with hearings. He just put them on a plane, signed a proclamation, and off the plane went because he said they're alien enemies. So the question is, can the president do that? And the law says, yes, he can. The Alien Enemy Act says, yes, he can. And it seems to be separate from the provisions of the 1952 and the 1965 statutes. So moving on. Now, the erasure of alien enemies from 8 U.S. Code Section 1182 does not mean suddenly all alien enemies declared under the Alien Enemy Act are suddenly admissible, however. So I was questioning, can they come to the country now? Can the enemy aliens come to the country? They removed it from inadmissible aliens. Well, under admissible aliens, they broadened the scope of inadmissible aliens beyond just alien enemies to include any alien not described who has been ordered removed, under this title or any other provision of laws is inadmissible, or departed from the United States, so while order was outstanding, etc., is inadmissible. So let's just read it again. Any alien under any other provision of law is inadmissible. That means any other provision of law. That includes the Alien Enemy Act. So I think these are the laws that are almost certainly going to come into play. They are in play. The president has invoked them. And yeah, these guys are inadmissible, so you don't have to worry. The president removed them, but no, other members of the gang are admissible because they're alien. They've been declared enemy aliens, and no, the 1965 Act removed enemy aliens from inadmissible aliens. No, it didn't. In fact, it broadened the scope of inadmissible aliens to include all provisions of law that invoke if someone who is subject to removal as an enemy alien is now also inadmissible under 8 U.S. Code Section 1182. Again, it says any alien under any other provision of law is inadmissible, including the Alien Enemy Act. So moving forward, read that again. Any alien removed under any other provision of law, including the Enemy Alien Act, is inadmissible, rather than repeal the 1798 law, which the 1965 and subsequent Congresses absolutely could have done. Congress can absolutely repeal the Alien Enemy Act, and they could have done so in 1965, but they didn't. And so we must consider all of these laws. You have to read them consistently. Yes, the 1965 law is the law of the land as well. But when the 1798 Act is invoked, either upon declaration of war or by proclamation by the president, its provisions come into effect. Those provisions are in effect. These, I think, removals will continue under President Trump's authority, which seems to be legal and constitutional. These are laws. This is not an imperial presidency. These are laws that Congress enacted over the years, over the centuries. These have been in place. This has been in place since almost the very beginning of the republic. This was under the John Adams administration, and it was never repealed. And in fact, it was utilized in World War II. And there's actually a court case about this. Ludecky v. Watkins in 1948. Here's the case, Ludecky v. Watkins. It's decided on June 21, 1948. And what do we find in it? It said, here's a description. As Congress explicitly recognized in the recent Administrative Procedure Act, some statutes, quote, preclude judicial review. Barring questions of interpretation and constitutionality, the Alien Enemy Act of 1798 is such a statute. Read that again. Barring questions of interpretation and constitutionality, the Alien Enemy Act is such a statute that precludes judicial review. You can review its constitutionality. You can say, oh, the Alien Enemy Act is unconstitutional, but that is not the argument that has been put forward by the ACLU and by the Judge Boasberg. Judge Boasberg is saying that these were trumped by the Immigration and Nationality Act. It says it right here. The violation of the Immigration and Nationality Act. Suffer violations of their rights under due process and the Immigration and Nationality Act. But as we just covered, the 1952 and 1965 acts did not repeal the Alien Enemy Act, so it's still in effect. I think that's a pretty good argument, and that if I had to guess, that's something like what the Trump administration is going to say. So let's go back to it. The language employed by the Fifth Congress could hardly be made clearer. Again, this is the 1948 Ludecky v. Watkins decision. Could not be any clearer. Or be rendered doubtful by the incomplete but not always dependable accounts we have of debates in the early years of Congress. Such was the scope of the act is established by controlling contemporaneous construction. Quote, the act concerning alien enemies, which confers on the president very great discretionary powers respecting their persons. That's C.J. Marshall in Brown v. United States. Quote, appears to me to be as unlimited as the legislature could make it. And that's J. Washington and Lockington v. Smith. The very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion. This view was expressed by Mr. Justice um, Iredell shortly after the act was passed, case of Fries, and every judge before whom the question has since come has held that the statute barred judicial review. We would so read the act if it became before us without the impressive gloss of history. And then it goes on. The political branch of the government has not brought the war with Germany to an end. This was in 1948 under the declaration of war. Now you could have a proclamation. President Trump has not brought his proclamation that there's an invasion underway to an end. Okay, so if they rule the same way, that the proclamation seems valid, he signed it. There was no auto pen. President Trump signed the proclamation, therefore the proclamation is still in effect. Okay, it proclaimed that a state of war still exists. The court would be assuming the functions of the political agencies of the government to yield to the suggestion that the unconditional surrender of Germany and the disintegration of the Nazi Reich have left Germany without a government capable of negotiating a treaty of peace. It is not for us to question a belief by the president that enemy aliens who were justifiably deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict, which is characteristic of a state of war, even when the guns are silent, but the peace of peace has not come. These matters of political judgment for which these are matters of political judgment for which judges have neither technical competence nor official responsibility. Again, invoking Marbury v. Madison, it's a political question with which the president has discretion. I think it's clear as day that the Constitution is on President Trump's side here, and the laws of the land are. That he is not acting arbitrarily. He is acting in accordance with the laws of the land, as we just read here on this live stream. In other words, the exercise of war powers, whether upon declaration of war or proclamation by the president that there is an invasion, are non-justiciable questions. The courts cannot consider the conduct of war. And so President Trump, confident in the law, instead of turning around, the planes continued to their destination and landed safely in San Salvador, El Salvador at 8:02 p.m. on March 15. The judge's order be damned. Here you have a local federal judge who is attempting to commandeer the president's absolute authority to secure the nation's borders and even to engage in foreign policy and to wage war, in this case by removing enemy aliens and having them removed to an ally of the United States, El Salvador, who has received and processed them into the country's prison system. They're in the prison system. They're out of the jurisdiction of the United States, Judge Bozeman. So I guess the question is now moot. If allowed to stand, Judge Boasberg's ruling, by hampering the ability of the president to wage war when Congress has authorized that he may repel an invasion, by definition poses a threat to national security. What's next? If President Trump orders airstrikes somewhere, I don't know, on the terrorist organizations in Venezuela or somewhere else, the drug cartels who have been declared terrorist organization and enemies of the United States, if he starts bombing them, is a judge going to issue a ruling saying the F-16s have to turn around? Come on. In essence, President Trump defied what at this point can only be called an imperial judiciary, and Trump is going to let the chips fall where they may. Again, this is Robert Romano. I'm the executive director of Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button, ring the bell for notifications, and have a good day. But first, I think we want to go to the chat here. I think that's a good idea. We can first remove the screen here. Let's see, how do we do that? We go here, and then we zoom in on me, and then we can start highlighting. Also, thank you everyone for tuning in here. We've been going on for about 30 minutes here. Dang it, it looks like Rumble didn't actually go live here. We'll have to fix this and upload this to Rumble later. So if you're tuning in there, I appreciate it. All right, let's see here. Connie Sippold writes, get them all out. That's a good idea. Let's get them all out. Let's see. Here's Linda Ackerman. Get them out. They came in illegally. That's true. Angela DG says, good, get them out of the United States. I'm seeing a pattern here. Let's see. Walty Jones says, funny thing, Biden administration went against judges' orders multiple times and nothing else happened or said so by President Trump. Getting rid of criminal illegals is what it was for the betterment of America. So I think he did the best thing. And so a lot of support for President Trump in the chat here. Appreciate your comments. Let's see, Beverly Rociato. Ignore these damn judges and impeach them if possible. Where's the AG on this? Attorney General, we mentioned Attorney General Pam Bondi. She's going to be establishing as the policy of the United States that the Tren de Aragua is subject to removal under the Alien Enemy Act. And again, these are foreign terrorist organizations now. So I believe other counterterrorism provisions of law will come into play, whether that includes the Patriot Act or other provisions of law. Certainly they're subject to removal. So I guess just put them on planes and get them out of here because there's some state of war that the president has declared. There's an invasion of the United States that's been taking place apparently for years. No president before Trump had said there was an invasion, but Trump, under his absolute authority to declare that there's an invasion, has done so under the proper proclamation that the law calls for. So I think that, but I think the Attorney General will be enforcing President Trump's orders. Here's Gregory Brault. Good job, President Trump. And then speaking of the terrorists, says, get out of our country. I think they should go home or go. Maybe we should, don't send them home. Send them to El Salvador. Let's see. Mike Funk says she's removed 2 judges so far. Let's see. Georgiana Hutler. Judiciary has no authority beyond the courtroom over the executive branch, specifically the president. We have to eliminate any and all members of Congress and Senate. And well, you mean like vote them out, who are protecting the invaders. AOC is getting fat. Stress eater? Ha ha ha. So yeah, there's a call. The judiciary certainly has no authority to do this. So what could Congress do? I think that these are political questions. The president, the courts can't get in the way of bullets, and they can't get in the way of the president's power to wage war. Again, if Trump starts sending F-16s to drop bombs on these terrorist organizations wherever they happen to be, under maybe the War Powers Act, or if Congress provides an explicit authorization, I don't think a judge is going to be able to issue a ruling saying turn the F-16s back. They can't bomb. I think that these are war powers. I think the president has pretty much the discretion he needs as commander in chief under the Constitution to do that. Let's see here. Peanut 3050 on YouTube. Where's Pam Bondi and our Second Amendment reform? Again, Pam Bondi's going to be enforcing these orders, I expect. She's definitely named in them. Here's John Stewart. Tell that son of a bitch to kiss your ass. We'll back you. Okay. Peanut 3050. Where is Pam Bondi? Again, where is Pam Bondi? So, it's okay, Peanut. I saw your comment. She's going to be enforcing these orders. These 250 enemy aliens, they were already on the plane. They were already on the tarmac. They were ready to take off. Trump signs the proclamation and off the plane goes. So I think that Trump has the full cooperation of the Department of Justice, the Department of Homeland Security, the Department of Defense, and every other department and agency. President Trump is in full control of the federal government, and that includes the Justice Department. So again, you don't have to spam the chat. That's okay. Let's see. Here's Breakdown. Why should Robert Romano have any rights? I'm a U.S. citizen. I was born in this country. And the Constitution applies to me. It applies to you. We all have rights under the Constitution. Let's see here. Peanut says, 3050, violations of our Constitution are far more important. Where is Pam Bondi and our Second Amendment reform? Well, I agree. She definitely needs to enact these orders, and she should. Where's the Second Amendment reforms that were promised? Selena Peden says, does this mean war? That's a really good question. Under the Alien Enemy Act, the president can issue the proclamation for these removals in the event of a declaration of war, or if he proclaims that there's been an invasion of the United States. So I think that's an emergency war power he is invoking, and that, yeah, you could say that there's a state of war between certainly between the drug cartels in the United States. After 9/11, I think the saying was that the terrorists had declared war on us, but we hadn't declared war on them. So President Trump is, I think he's going forward. He's saying these are invaders and we're going to repel them, whether Congress has acted or not. They're certainly a public nuisance and they're engaged in irregular kinds of warfare in the United States. I mean, they're pretty well armed, these drug cartel gangs. And so I think that President Trump is taking this deadly seriously. And he's using every power, every tool in the shed to, take care of it. Anything that Congress has authorized that says he can get rid of these criminal aliens and terrorists, he's doing it. So President Trump is, I think he's doing what he has to do. He's the president. We only get one president at a time. Under Article 2, he is the president, the singular executive. The executive power shall be vested in a president of the United States. There's no other president, and certainly Judge Boasberg. And we should just call him Judge Bozo, I guess. He has no authority to wield the Article 2 executive power. Only President Trump can do that. He can wage war against these terrorist organizations. If he says there's an invasion, well, they should be securing the border. And he's sending the military to the border to repel this invasion. If they can encounter these drug cartels, I expect there might be some shooting. I mean, are they going to issue a court order saying, "Oh my God, the National Guard is shooting at the terrorist who shot at the National Guard. Stop the shooting. They can't do it. We're issuing a court order. Stop firing." And it's like, no, the president is commander in chief. He can order that military action when there's an invasion, and President Trump has properly proclaimed there's an invasion. So we're getting to the bottom of the chats here. F these treasonous, fascist, deep state, globalist sellouts. Obama appointed commie judges. They should be rounded up, arrested, and face the gallows for treason and insurrection. They're U.S. citizens and as well. The judge is issuing a ruling which we disagree with vociferously. We expect, and I believe that President Trump is already appealing to the Court of Appeals. Expect ultimately that these cases, like so many others, will be going to the U.S. Supreme Court. One good example, and I think we just read through all of the laws. You don't have to agree with my opinion. You might say, no, the Supreme Court's going to strike down what Trump did, and it's like, well, maybe they will. But I think that the law, we read the laws, and I think they're firmly in the president's. They're in line with what he's done. He's properly invoked them. Other cases are going to include the foreign aid cases. Actually, very interesting. So if you go back to 1793, the first president of the United States, President George Washington, there was a war breaking out between France, Great Britain, and other European countries. And France was calling in our treaty with France. And President Washington issued what's called the Proclamation of Neutrality. And he said, we are not following the treaty. He basically terminated or suspended the treaty with France. So if you can terminate, and this has been done by more than once by presidents. We've had Jimmy Carter suspended or terminated the alliance with Taiwan. You had President George W. Bush terminate the anti-ballistic missile treaty. President Donald Trump, he ended the intermediate nuclear forces treaties. I actually disagree with both of those decisions. I think they've made a nuclear arms race more likely. And so there you go. Oh, well, Robert disagreed with President Trump. Put him in the gallows. What a traitor. No. I'm just noting the fact that presidents have the power to terminate treaties with foreign countries that were adopted by 2/3 of the Senate. So do you think the president can suspend foreign aid to a country that's no longer considered an ally? I think he could. I don't think we have to spend that money. I don't think we have to keep on shipping billions of dollars overseas to countries who hate our guts. I think that that's probably not a good policy. But President Trump, if he can suspend a treaty just like every other president, then he can suspend the foreign aid. So, notwithstanding the Supreme Court refusing to deal with $2 billion of what is already called services rendered a foreign aid. So the NGO or whoever, non-governmental organization that was receiving the $2 billion, they said, we already rendered these services to the United States. We expect to be paid. Here's our contract. Please, have them send us the money. So the local district court said, you have to send this money. But the injunction did not cover the issuance of new foreign aid contracts. So so basically all this narrow court ruling on foreign aid deals with is once the fiscal, we're dealing with the monies that Biden had already let out the door. So come September 30th, when the fiscal year ends and all of these contracts, the duration of their funding come to an end, guess what's going to happen? President Trump is not going to let any more foreign aid contracts that he disagrees with out. So the Biden contracts and other contracts that go back years and years that have been previously approved under previous administrations, including the Trump or Obama administrations, they're simply not going to be renewed. So ultimately, one way or another, the foreign aid is going to stop simply by not issuing new foreign aid. And I think it's a very narrow ruling. I mean, like, for example, if President Volodymyr Zelensky of Ukraine starts going to the U.S. District Court to say, give me my military aid, yeah, then I think we're going to have a big problem. But otherwise, I think the president's Article 2 executive powers are well intact. And that, again, he's going to, either prevail upon that question of services rendered or not. But I don't think it impacts his full ability to just say, we're not doing foreign aid to that country. They hate our guts. He can just say, they hate our guts. Don't give them the foreign aid. And those are contracts. They're not, Congress approves a discretionary budget to these departments and agencies. They say, here's a few $1 billion to do X, Y, or Z, or to issue grants and contracts. And then the executive branch decides who the contracts go to. It could be for any particular purpose. In this case, we're talking about foreign aid. And so, yeah, the president has the discretion to either let the new contracts, or I argue, if he can suspend a treaty, he can suspend the ongoing contracts of foreign aid, because that is the discourse between nations. We're giving aid to a country, and then we say, no, actually, that's a bad idea. We shouldn't give aid to that country anymore. They hate our guts, or they're harboring terrorists, or etc. The president has that discretion. That's what Article 2, that's what the executive authority is all about. And so I fully expect that President Trump is going to prevail in these judicial proceedings. So I think it's just it's a very straightforward case. The president has declared that the Tren de Aragua, other criminal cartels, drug cartels from Venezuela and elsewhere, on the our enemy aliens, they're terrorist organizations. So get the heck out of this country. I think the president's very much got the law on his side here. We got one more chat here. Betsy Burns says, it's good to see and hear you again. It's good to see you too, Betsy. Just an administrative note. You will remember Rick Manning, former president of Americans for Limited Government. Today is his very first day at the U.S. Department of Labor. And while he's over there, he's left me in charge of Americans for Limited Government. I'm the new executive director of both Americans for Limited Government and Americans for Limited Government Foundation. And we wish Rick very good luck working at the Department of Labor. He was actually a former public affairs officer, chief of staff of public affairs at the Department of Labor under the George W. Bush administration as well. So he's been going back into government. And so I will hold down the fort, Rick, here at ALG. Again, this is Robert Romano, Executive Director of Americans for Limited Government and Americans for Limited Government Foundation. Hit that subscribe button, ring the bell for notifications, and have a good evening.